meetings. 3, respect one another as elected representatives of the community and be open-minded and recognize one another's strengths and the value of diverse perspectives and mutual commitment to the mission and vision of the district. 4, allow members to complete their thoughts and statements before others comment. Allow members to be heard and listen to all perspectives with an open mind. 5, stay focused on the task at hand and respectfully redirect each other when needed. 6, maintain confidentiality and communicate per board policies. Ensure trust and transparency in all dealings. And 7, after the vote is cast, leave meetings united as one voice, no matter the outcome.
All right, thank you, Madam Vice President. On to the adoption of the meeting agenda.
So moved.
Second.
I have Ms. Gray as first and Mr. Gaudelberger as second.
I think I noticed there were speaker slips on the table, but I don't think we have speakers, but I don't see a place on the agenda. Could we add public speaking just to recognize that we had that option available at this meeting?
We cannot change. This is a special meeting, and we did not have public participation on there, so we can remove those speaker slips. On to roll call, please.
Mrs. Walsh.
Aye.
Mrs. Gray.
Aye.
Mr. Bauer.
Aye.
Mrs. Daudelberger.
Aye.
And Mr. Kirschner.
No.
All right, on to board items discussing the Groveport Madison High School athletic field naming rights. I have a few comments I'd like to state. Mr. Bell's 10-year high school stadium naming rights under the agreement enacted between the parties in 2017 were expressly conditional. The agreement at Section 11 provides for the district to terminate such rights immediately upon notice that Mr. Bell has engaged in misconduct involving moral turpitude. Another basis for termination is Bell's failure to make regular payments as scheduled. The Franklin County Common Pleas Court's civil decision adjudicating Mr. Bell as personally liable for $25 million in damages for unlawful sexual contact involving a minor is grave immoral conduct, warranting immediate termination. The judicial verdict prompted the district superintendent to order the removal of Bell's name from all Groveport Madison High School stadium signage and the high school athletic field forthwith. Mr. Bell's failure to continue payments as called for in the agreement is further evidence of his material breach. This district took the name removal actions only after being apprised of a final judicial verdict. Upon termination, the naming agreement with Mr. Bell allows the district to keep payments received. Mr. Bell's appeal rights within the legal system do not give him a right to appeal the district's removal decision, and for the present time, the stadium will revert to its original designation.
Thank you. How was that prepared?
How was what prepared?
This statement from the board, how was it prepared?
That was my statement.
Okay, thank you.
Do you have a copy of your statement? I'm having, it's kind of difficult. It's so long.
Sure, I can email it to you.
So for my part, the contract also stipulates remedies and notification, and it is a board contract. So based on our actions, we did request a meeting as soon as we saw this for Tuesday. And then we got to view on Facebook that it was already taken care of. So my view is that if I was offended by Mr. Bell's action, as we probably all were, I could just go onto the field and spray paint it all green and cover it over and remove all the signage. Or maybe a band parent or athletic director could. Anybody can just do what they want. This was a board contract and required board action. There is no standing authorization that would allow an individual to just go on and say, oh, the contract's breached, I determined it on my own, or maybe there was some communication. From my perspective, the decision, the contract is a board contract. The decision should have been a board decision. And if a board decision was made, I don't know how I was not made aware of it. Additionally, we've got 4 years where maybe there's one piece of evidence where we tried to collect money and never called him on breach. And I would say that is the result of a lack of a financial committee. I think if you had a good financial committee, that they would have been communicating with the band boosters and the athletic boosters and looking at the different finances of our district, and this would have been discovered. I discovered it long before I was on the board, and I'm the reason, I believe, when talking to Garrett Lee and Jeff at the time, that letter ever went out asking for the $150,000. I came in and asked where the money was at the time that the levy failed. They called me into a meeting. I may be wrong, but I knew back then, they told me back then they were collecting the money. So it's something we should have been visible of. Whether or not you agree, I don't know what happened. I can tell you that back when the levy failed and Garrett Lee called me in to meet, I was asking about this issue. So thank you.
I'd just like to say that our treasurer just gave us copies of letters that were sent out, certified mail, to his representatives trying to collect the money.
In addition to that, I know that when I first,
Two of them were sent out certified, not all of them. And the third one was not sent out, but our contract does say that, we have to send a 30-day notice. So I'm curious how this, I'm not saying I disagree with what happened, mind you. I'm saying the way that it happened, and are you gonna be sending a copy of your, was that a motion or was that a resolution or something, Seth? I don't know what you read.
No, not a motion or
Just a
a
statement?
that was my statement. Yeah.
Okay.
Yeah.
I'm sorry, I just didn't see the first part of it. It's kind of scrolls quickly.
Yeah.
Thank you.
Yeah. Yeah.
But so, I guess I would like to have more information on how the decision was made, and did we send out our 30-day remedy as our contract says we have to?
And I'll just add from my vantage point, trying to follow processes, trying to make sure we don't misstep. I don't anticipate a lawsuit from Mr. Bell. I don't think he's got the means or the motive at this point. I think he's got bigger fish to fry. But at the same time, is trying to put a process in place, an executive session, to make sure that before we did this stuff, that we reviewed with Bricker and Eckler, who authored the contract, that we had given our correct remedy. You can say immediate, but there's also contract language in there that calls for us to provide the 30 days. Obviously, 30-day notice should have gone out probably years ago, but I tried to create a process that would seem to be in keeping with board policy, board norms, and just get the view on Facebook. Never mind, it's all taken care of. So that seems a little wag the tail to me, the tail wagging the dog to me.
So it says under section 11. Does everyone have a copy of the contract?
Let me bring it up, please. Give me a second.
So I do want to ask.
We're not. So here's the thing.
Wait,
None of us are here to
wait,
practice.
let me finish
Go
what I
ahead.
started.
Sorry.
Did anybody talk to our attorney before removal of the sign? Seth, superintendent, group,
Yes, I did.
anybody else? Okay.
I did as well.
And did he have a what? I'm sorry. Did you say you did too, Seth?
Yes. Yes.
Okay. So did he have a comment on this clause number 11?
Yes. So essentially section 11, where it says that the board shall be entitled to terminate this agreement immediately on notice on Bell in the event that Bell is convicted of a felony or commits any offense or crime involving moral turpitude, or is banned or indefinitely suspended from the NFL.
Awesome. That's perfect. Thank
So
you.
was he convicted?
Thank you. That perfectly makes my point. The board is two people. You don't need us. Right? The board is you and the superintendent. You don't need us.
No, that's not what I'm saying at all.
That's what happened.
It's
If
the
you can
board.
contact,
Mr.
if you can
Kirshner.
contact the attorney, one board member, and you can get an opinion, and then you can act. You might as well build a building without talking to us. You might as well name a building across the street and not talk to the board. There are standing authorizations that are formed through board policy. This isn't one of them. And by the way, we would have been through the board policy. Things would make sense, but no, we won't do policy committee meetings. So here we are. There is no standing authorization for you or for the superintendent to contact our attorney and make a decision like this. It's a board decision, it's a board contract.
And it was done after I had asked if we could have a special meeting on this issue to discuss it as a board. Why is that?
So I would say I don't know exactly why you think that just because you called a special meeting that individuals weren't asking questions because we all saw the news article. You guys apparently were having conversation. We all were trying to find out what was going on. So just because your email came out when it did not mean that others were not asking some of the same questions. I just want to say that I think that's great that we all have a concern, and I think that it's great that we all are here to discuss that. But just because that email came out requesting a special meeting does not mean that conversations weren't had to then be addressed to the entire board. So I just wanted to just make sure I say that because I think we are all here to do the right thing. I don't think anyone's here to do anything. I would hope not, but you know, that's neither here nor there.
I don't think
But
anybody's,
I'm
I'm
just
sorry, I'm having a hard time following what
okay.
you're
I can
saying.
start over
It's
for
like
you
a
if you
lot.
like. Okay, would
Can you
you like for
condense
me?
it maybe?
Would you like for me to start over, Kathy, for you?
Yeah, you could start over or condense it. That would be great.
Okay. So I stated that with, and your statement was about this came out after your email, and I stated just as much as you
Which
had.
email?
You said you just stated that you called for a special meeting or requested a special meeting, so it either had to come via email or phone call or whatever method you chose. I don't know. I assume so, email or phone call, whatever that looks like. So with that, I'm saying that just because you sent that does not mean that others were not asking some of the same questions and working on something
Well, I
prior
didn't
to
say
that.
nobody else was asking. I'm just
Well, you
saying
said it
it
came
was
out.
important to have a
Kathy, I was
meeting
talking.
of
Okay,
the board before a
you guys are
decision
gonna
was
just
made
do.
without the board as
You
a
guys
whole.
are gonna do whatever. It doesn't matter. I
Can,
I'm
guess.
can
sorry,
we
I thought
speak
you were
one at a
done.
time?
I'm sorry, I thought you were done. I apologize.
So what I just heard was we were all talking about it. We were all thinking the same thing. What I don't understand and what I don't see is a transparency where the public can see or where I can see how the decision was made. So the decision was made. I wasn't part of it. I'm a board. We do our business not through individual communications to anyone or to the superintendent. We do our business as a group. So that is what I don't see. I don't see us coming together. I see one person talking to an attorney. I don't see all of us talking to an attorney and making a board decision on a board contract.
If I can first state, I thought we were coming here to talk about the naming rights of the athletic field, the naming rights. But uh, I did talk to our attorney. My first question was, does this take board action to undo this? The answer was no. That this was a breach, it could be enacted on. As we know in board policy and statute, it spells out the roles and responsibilities of the board, the roles and responsibilities of the superintendent. When I found out about this and I had the authority to do this, I took action to have those names removed. I'm in charge of all the day-to-day the day-to-day action of the school district. We make hundreds of decisions every day that doesn't come to the board. Those decisions were made prior to. I don't know when the request was sent from Mrs. Walsh for a special meeting, but those decisions that were made prior to me even knowing there was a request for a special meeting, to the best of my recollection at this point, it was we have a major situation where there is very serious content with the name of the person on our field. It did not require board action based on response from our legal counsel. So I took administrative action to do that.
May I ask
And
if
as
that, I have a question. I'm sorry, go ahead. I didn't mean to interrupt.
That it was my understanding too that the superintendent takes care of the day-to-day operations, and I included that in the day-to-day operations
right, and I think that's
and
also.
to carry out legal obligations, which is this was a legal obligation.
But what we can do, I know that he has that right under 3319, I think the Ohio Revised Code. So with that, we can at least here as the board affirm what has happened because that was what was in the best interest of the district if we agree with that. So as a board coming here today, he did his due diligence as speaking with the attorney to do the do the removal. But at this point at the board, we can affirm that decision if that would then um, be more in line with what you're stating, Mr. Kirshner.
Okay, and I appreciate everything that's been said. What I will say is a couple things. One is I got a call from our board attorney that said that I stated, and this will come up a little later, but I need to give this example, that I stated the name, grade level, and school of a student that we were going to be investigating. And that was put in writing. So there's a certain board attorney that I wouldn't give 2 cents for. But secondly, all this communication, if there's communication between the treasurer and a board attorney, why don't I know?
Mr. Grube sent out an update on, was it Friday, I believe? The same day to the entire board.
Right. So the same day as the action took place?
Yes, it was
Right.
the same day, correct?
That's not my question.
Yeah,
If
same
there's
day.
deliberation going on that this is not the board's responsibility, this is outside the board's scope with an attorney, I think that would be good because I would certainly want to weigh in possibly, or maybe ask for a second opinion because we get some really great opinions from some of our attorneys, and standing authorizations are standing authorizations, and school naming is one that is specifically to the board. There's many items that don't fall under this. And again, we may have a difference of opinion, but it would be great if we could know when these conversations are happening, and then we wouldn't feel like, great, I'm seeing it on, we called for a meeting and here it is on Facebook. So that's all I have. I'm sorry. No more.
Well, I would like to say another thing, unless somebody was waiting. So, we have a policy, FF, naming facilities, that's a board responsibility. We have a contract, 11, he was not convicted of a crime, so I just really want to make sure we dot our i's and cross our t's. And I think that's a decision the board should make. Everyday business, this is not everyday business. This is out of the norm business with a contract that is over the amount of everyday business being $750,000. I think it's just, if I can sign into a meeting here and then leave so you guys can do what you're going to do, or we can act like a board of a whole. And we're not doing that. And if the president talks to the attorney, that should be a phone call. If there's, or an email saying, hey, I talked to the attorney, this is what was said, or we need to have a meeting to discuss what was said. It should be discussed as the board as a whole.
I would just like to say that we have contracts that are much more than $750,000 that our superintendent implements and follows through on those contracts. The contract did state that for any egregious behavior that it could be removed. So therefore I felt like he was following according to the contract. Also, since we are supposed to be talking about the renaming of the facilities, I would like to talk about that and would like for it to continue to be called Cruiser Stadium and no longer have a name of a field, just Cruiser Stadium.
I agree. I like that, Ms. Gray, as well. And I definitely concur with your comments as far as the superintendent doing his due diligence that day, and as you notated in the contract as well. Thank you.
Yep, and I
Okay,
agree too.
so we have a motion. Is that a motion, Libby?
No, I just said I would like to have a discussion, and that
Yeah.
was my suggestion.
Right. I agree. I agree. As soon as I saw this, I said Cruiser Stadium has always been what I've known it as, and I think that would be appropriate.
Yep, I agree as well.
So I'll make a motion to rename the stadium as, I'll keep the name as Cruiser Stadium, but have no name on the field.
So moved. I mean, second.
Mrs. Gray is first, Mrs. Dottelberger is second.
Could I clarify, this is not precluding us from additional naming rights in the future, is that true?
If our policy allows us at any time to be able to do that.
She said our policy allows at any time for us to do that. So right now it's just for the purposes of the current removal. It wasn't an indefinite motion in her
Correct.
language.
Just
Any
want to be
board
sure.
Can
Thank
bring
you.
it up to have it changed or whatever.
What is it? It says it was an infinite motion in her language.
I stated because Mr. Kirshner was asking about,
Yeah.
was it a permanent, like we couldn't ask for it again. And I said she did not, her language did not include indefinitely leaving the name off the field. It was just for this time being to continue with Cruiser Stadium and remove the name of the field. That's all.
So the motion will be to temporarily name the stadium Cruiser Stadium.
The stadium's already named Cruiser Stadium, if I'm not
Yeah,
mistaken.
it's already.
It was
named
just the
Cruiser
field that had a special name. And so we're saying, the motion was to ensure we just don't have a name for the field anymore, basically.
Yeah, to clarify, Cruiser Stadium was in our agreement with, was still in the name in our agreement, so,
There just won't be a name on the field.
exactly, thank you.
And the attorney said that we do not have to follow that number 11 of his contract. We're good with that. Our attorney said we have done that. We have followed that to the T, and there's no chance of us being held accountable by Mr. Bell as us being in breach of contract, which is item number 10.
I'm not an attorney, but I would recommend you emailing our attorney just so that you can verify on your own.
Well, I don't want to take a vote before we contract and know for 100% sure that we're following this contract as it is written.
So, can we move on? Yeah.
Yep,
thank
on to roll call, please.
Mr. Kirshner,
Roll call for which?
just the Cruiser Stadium. Mr. Kirshner,
Aye.
Mrs. Dotterberger,
Aye.
Mr. Bauer,
Aye.
Ms. Gray,
Aye.
and Ms. Walsh.
No.
All right, motion passes.
May I make one comment? The contract was, this is just a thought, contract was written by Bricker Neckler, and it might be wise if that attorney, I don't know if he still is there, that drafted it, might be a good person to follow up with.
I believe he passed away of
He passed
cancer.
away.
Yeah.
So regardless, I do think that we should send out the notice of breach with 30 days to cure, and then mention the action that's taken and subject to cure. I also, the reason that I wanted a meeting is one of the thoughts that I had, or a couple thoughts I had was, one was obviously Le'Veon has hurt his image and our image, and it's very sad because he's an alumni and was a very kind person, as I understand. But you know, I did want to give him the opportunity to financially remedy and explain our actions thoroughly to him and expectations, and I think by doing what we did, we may, I don't know that we'd ever collect a penny from him, but we wouldn't know because we haven't done much for 3 years. So I think there was probably some opportunities to approach this differently that may have provided some possible long shot financial benefits for the district, as well as outlining why the name wouldn't be there, etc. So thank you.
So, just a point of clarification, I will follow whatever the board direction is. As obviously it's my job to do that. But are you saying that if they would cure the financial part of this, that you'd be interested in putting his name back up?
No, that's not what I said at all. What I was saying is, um, if I were to if we were to approach this together, I hope for a gracious communication to him, expressing gratitude, sorrow, and here's where we are, and offering him the opportunity to fulfill his financial position, but at the same time explaining our position and why the damage has been made to the reputation and why we can't, allow him to run, children's, youth, etc. Events at our district. That's what I was referring to.
So, just a couple of things as well. So, thank you for your comments. But I also want to remind since this is recorded, and think about the time frame when this was happening. This is all also during around
A
COVID.
point of order, can you start over, because it's saying buffaloes and symptoms.
Okay, I'm sorry.
I'm sorry.
I'll slow down a little slower.
Thank you.
I said that I wanted to also remind everyone during this time frame, when you look at the letters and things, that this is also during COVID. This is also when we had our students at home. We were one to one. Everybody's just trying to live, and then also returning back to school, then also busing. So definitely not an excuse, but just want to also keep that in the forefront of what was happening. In addition to um, there, from what I'm understanding, is that there were ways that, given the opportunity to cure, if, I know that there was press that came out at some point where maybe was not doing NFL, but was going to box and maybe going to music and entertainment. So still giving him the opportunity to cure the financial piece versus moving into the removal process for that, because we could still work that relationship, or and then also family is still here, if I'm not mistaken, and not to, bring that out with that piece and try to embarrass the family. So just kind of want to put that on the record as well. But I do believe that for the moral portion of it, I don't think there's any curing of that per se.
I
All right.
agree. I agree. Thank you.
Moving on to item 2, discuss a regulated individual, and I'd like to open up with a brief statement on this as well. We are all here to serve Cruiser students, their families, and all school district residents. Last week, this board and the superintendent authorized an external independent third party's comprehensive review of certain classroom-related matters. It's my understanding that the third party review will proceed expeditiously with an eye toward providing specific findings and recommendations for our review in April. Since this review is pre-decisional, I ask that each of us refrain from any further comments to preserve the integrity of the third party's work. There will be ample opportunity for all members to provide input once the independent third party review is complete. The interaction of state and federal student privacy laws with our board policies can be complicated and confusing. I do believe each of us wants to do what is right. I'm mindful that there has been a lot of conversation among us and emails back and forth lately seeking clarity. To help us navigate these complex issues, our legal counsel is preparing a comprehensive legal update on this topic. The legal update will give us an in-depth review of the applicable student privacy laws and regulations, and it will provide us with specific examples of situations where a school official has a right to review student records with personally identifiable student information consistent with law and board policy. At this time, I'd like to offer a gentle reminder to everyone that any comments this evening stick to general observations, avoiding references to any specific student situation in observance with state and federal student privacy laws. Thank you.
Great. Thank you. So, if I had committed an offense and I needed investigated, or you felt that I needed investigated, I am sure that you would say, Mr. Kirschner, can you please go find us an investigator? So in this instance, we have people here on the board and people that are selecting the investigator that are subject to the investigation. The motion was made to find an independent investigator, and I do not believe that investigator should have been selected as it was. I think that's inappropriate. I think the board should have picked a law firm that is not, um, that is independent from the individuals that will be, uh, being investigated, and they should pick an investigator. And I also believe that the investigator should have a directive or a letter of engagement that is forged by the board based on our knowledge and our concerns in this matter. And I'm, I'm just surprised and disappointed in the way that this has proceeded. And as far as legal goes, again, I have an email that came from I don't know where that says that I've already named the individual, what grade they're in, and their age, and that there's FERPA violation because of some obscure reference to the person's age once upon a time or currently, with no reference to a date or anything else. So your opportunity, and I've looked very carefully at FERPA laws, and your opportunity to identify a student from the language that was put in the meeting notice is about the same as winning the lottery. And by the way, when two board members sign a meeting notice, that is a legal notice. If we want a board policy that says when a legal notice is formed, we would like it reviewed by our legal team, that would be great. However, to take a legally formed board notification and just discard it isn't within anyone's right. So I don't think this process is going well. I don't think it was born as it should be. I think that we should pick a firm that is independent, and I think we have a firm that is not independent, that is very opinionated and can sometimes be weaponized. And I think we should pick one like Bricker or somebody that we haven't used in a while and let them pick an independent investigator and not pick it, or not have an individual sitting up here pick it.
And the individual you're referring to clearly is me. And so my question is, am I under investigation for something?
Without getting into the specifics, the complaint was that they called X, I called X, I called X, I didn't get a return call, I didn't get follow-ups. I requested public information, I didn't get follow-ups.
No, you didn't get the answers you wanted.
I'm not talking about me.
Okay.
We're not investigating for me. I'm
Okay.
talking about the people involved here.
So
Said their first contacts were you, the assistant superintendent, the principal, the police, Seth, etc. So we do have people that are here that would be subject to this review. So yeah.
okay. I mean, if again, at the direction of the board, if the board wants to make day-to-day decisions about things and go against what the board policy says about the role of the board and the role of the superintendent, I'll follow the lead of the board for doing this. I tried to expeditiously get this moving. It was approved by the board. No one stated that night that it was the board doing any of those selection. I went to an investigator who we and many other Central Ohio districts have worked with and asked for availability. But ultimately, you know, again, I feel like this evening is more about being critical of the what and how decisions have been made, not about the decisions that were allegedly put on the agenda. This feels like a way to try to attack me publicly and be critical of the decisions that all I'm trying to do is follow the direction of the board.
Can I chime in?
I was going to state that this isn't a law firm, I believe, doing the investigation. I don't believe it is, but I will confirm. If not, I believe it is somebody else. I don't think it's a law firm, though, but I'll have to ask. But I think that information will be
Believe it
forthcoming.
is.
Yes, I do not believe it's a law firm. I know our law firm was not. I don't believe it was asked.
Yeah, and I wasn't suggesting a
Okay.
law firm had to do it.
Okay.
I was
I'm sorry.
suggesting because, for instance, you know, Adam had thrown out there that he could recommend someone, or I was suggesting that we select a law firm to find the independent investigator because
You're saying
I
the
don't
board
want
would
it-
select the law firm.
I wouldn't know and you wouldn't know if the investigator is a friend of mine or a friend of anybody else's, and I'm not suggesting they are. I'm just saying I want that independence. I don't want to worry about a good old boy network or anything else. And I'm not throwing accusations. I'm simply saying we voted for something independent, and I just want to know that it is, that it's not. That's it. That is independent. There won't be any bias, etc. So
I guess in my mind, we're hiring a professional, and what you're doing is accusing a professional of being unprofessional. And so I think that's very disrespectful.
In regards to Superintendent Group's, statement, he following the, I do appreciate you reaching out and following the direction of the board, and he does make a great point. If the request was to, we would do this election, then I think I apologize if that was what we wanted. That wasn't clear in that motion. My thought was that we were going to pass it along so that we can get an independent investigation and then go from there. So I do thank you for what you did do, Mr. Group, very quickly, and at least trying to find someone based off our recommendation just less than a week ago, actually.
And please let me be clear, if that's a desire of the board, that's fine. I'm just trying to get things completed.
We understand.
Yes, I'm fine with what you did.
So, Seth, I had a question from your statement. You said review is pre-decisional. Could you explain what you mean by that?
Sorry, can you explain what you want me to explain regarding that?
Yeah, that's right. Yes, if you could explain what you mean by pre-decisional. You mean we voted on it? So I'm not sure what
Yes.
what your
We voted,
thoughts
yeah,
were on that.
we voted on an external investigation. That's basically what that's saying.
Okay, that's what I
Yep.
thought. I just wanted to be sure. I
Yeah,
was
absolutely.
understanding,
Yep.
getting clarification there. So, and Jamie, yes, you said, Jamie, you're in charge of the day-to-day operations, absolutely. But I think that John's thing is an independent, and that's what it said, and you can go back and look at the recording and the words there, independent investigation. So, I mean, I kind of see both sides of the coin. It's between a rock and a hard place, I see where Jamie's like, "Oh, you're attacking me." We're not attacking you. We're looking at the day-to-day operations as it um, pertains to this particular situation. So maybe just going to Bricker and Eckler, or they're one of our approved legal firms, and saying, "Hey, find a person." They know people. They do it all the time. That's what they do all the time. Just let them hire somebody, and then it's an independent, because we're not picking them. And the board, and it also in the motion said that the board would do the investigation. So,
yeah,
I don't know.
well, and
It's,
I'll break
so I
it
think
down.
that's
I'll
a good
break it
idea.
down and make it so you can all understand it better. I
Well,
got a
please
call.
do.
I got a call from our attorney. Okay, and you can be snarky all you want, Libby. I got a call from our attorney, and he said that I thought that the student had been personally assaulted, physically assaulted, and then that I had done this, and I had done this, and I had done
Oh.
this, including putting out the person's personal information, all this. So I don't know where that opinion comes from or where that idea comes from, but obviously it's going to make me skeptical of the process, and that's where I am. I would move that we contact Bricker and Eckler. I have no ties with them, and we ask them to provide an independent investigation, and then I would ask that Seth or our Vice President Latoya reach out, and we create, or at least ask the board members of what the scope should be. I mean, the complaint there have been very specific things brought forward that conflict with what we were told. And I'm not allowed to have visibility, but, and I don't want to get very specific, but, oh, they're doing fine. No, they're great. We're told that they're doing well. I'm told their grades are down here. Here's an example. A parent, here's the logic that I have to ask you to understand. So, a parent that's working 3 jobs, scraping, trying to make ends meet, we're told they were offered counseling. They say, "Are you kidding me? Do you think I would have spent $1,600 out of my pocket to get personal counseling for my student if counseling had been offered?" So I see grave discrepancies in what was reported to us and what I'm hearing. And I'm not taking a position on either one, but these are items, and there are many more that I would want to see investigated, including, did somebody say X? Did somebody, refuse to respond to emails? Was the person interviewed without their parent and without their parent's knowledge?
Mr. Kirschner,
So-
I think that we might be crossing a line here. If you do you have a motion that you're making?
Yes, I'm moving that we contact Bricker and Eckler and that we ask them to provide an independent investigator.
A second.
I have Mr. Kirschner as first and Mrs. Walsh as second.
And
What I would like to ask, Mr. Grove, you have already reached out to a firm for them to hire somebody, is that correct?
Yes, I reached out last week. I put that in the board update and met with the individual today, but it's a proposed contract. And again, if the board wants to go a different direction, that's not a problem. I mean, honestly, the investigator wanted to know how tonight was going to go before there was even agreement to do the investigation. So,
well, do you have a copy of that contract? Do you have a copy of?
I do have a copy of the
I
contract.
mean,
It's an
that's
hourly
part of what we're
it's an hourly-
discussing right now tonight.
I'm sorry.
Can we talk one at a time, please?
I said that's part of what we're discussing right now tonight, discussion of this, and that's what the original notice was about, hiring the investigator, so I think we should have that during this discussion.
Well, for me, if as the board, we've already decided on an independent. I would like to see what would come first before going to another firm to see what we could have, because then there's the finder's fee for that as well. But there's no, I'm open to whatever, but I think I would like to see first what we already have. But it's since this is discussion for this motion, correct? Am I following? Okay. So I would personally just like to see where we're at first, since those if the board was going to be the deciding factor, that wasn't clear. I thought the clarity was to move quickly. I do trust that if we hire someone independently, that their professionalism, as Ms. Gray put, would be professional, and they would want to adhere to whatever standards as an investigator to provide professional services, because that's also their name and their reputation as well. So that's just my comment for that.
If I could
Yeah, go ahead.
comment, even though I trust this person or respect this person a great deal, she does investigations all over Central Ohio, a lot of other districts. I would at this point tend to ask the board to go ahead and move to Bricker or somebody else to do this, because I feel like this is going to be tainted, and if there's accusation because I selected the person, why waste the time if that's going to be discredited later? So let's just break clean and go to somebody totally outside. I was again trying to save us money and move forward quickly, but that's fine.
And just to clarify, I'm not suggesting the board select them. I'm suggesting that we allow the law firm to select them that's independent.
I'm fine with paying a law firm to select a consultant to come in and do the investigation.
Any other discussion?
No, thank you for your time. Appreciate it. I would say one thing, and that is clearly we can communicate amongst each other about things that are administrative. So things we want on the agenda, things we want to talk about, and we need to obviously clearly do a better job of that, so that when we come here, we have an idea of what to expect. So I think informing our agendas, etc., we should certainly do a better job of intercommunicating.
I would say, Seth or Latoya, if you two are doing this to look at our board policy BCG and engaging a legal counsel, there's specific steps. I would want to make sure that those were followed.
Any other discussion? On to roll call, please.
Mrs. Walsh?
Can you restate the
Motion is to contact Bricker and Graydon it's inadequate. We're grading now to get an independent investigator.
Aye.
Mrs. Gray,
No.
Mr. Bauer,
No.
Mrs. Dotterberger,
No.
and Mr. Kirschner.
Aye. May I ask the name of the investigator?
I chair the contract.
Thank you.
All right, on to item F, motion to adjourn.
So moved.
Second.
Okay. Have Mrs. Dowdleberger as
Yep.
first
And
and
Captain.
Mrs. Walsh as second.
Mrs. Walsh,
Aye. Yes.
Mrs. Gray,
Aye.
Mr. Bauer,
Aye.
Mrs. Dotterberger,
Aye.
and Mr. Kirschner.
Aye.
And it's
7:46. We are adjourned.